them filed a complaint, as you well know, against Ben Schneider, Reckless Ben, and others. And one of the causes of action or charges is RICO. Violation of RICO. So stay tuned here. I'm going to break down what RICO means, where RICO came from, what it's all about, the type of law it is, its purpose, and why it's crazy that Reckless Ben is being charged with RICO. Suave. So let's get started. I've got some notes. The Racketeer, Influenced, and Corrupt Organizations Act. That's where RICO comes from. It was enacted as Title IX of the Organized Crime Control Act of 1970, signed into law by President Richard Nixon. I'm not a crook.
Well, I'm not a crook.
On October 15th, 1970. RICO legislation can trace its roots all the way back to the 1950s congressional hearings on the Mafia, designed to let prosecutors target top criminal bosses in the Mafia. Those criminal bosses who insulated themselves from direct connection to the crimes. They were just the fat cats receiving all the money, while all of the enforcers and all of those people were out taking money and illegal activity and all that sort of stuff. There were high-profile congressional hearings exposing deep financial ties between the national mob syndicates and the local Las Vegas figures involved in Nevada's casino business. The investigation was led by Senator Estes Kefauver. Kefauver is a pretty well-known name here in Las Vegas. He was a senator from Tennessee, but he led these 1951 hearings in what we now call the Kefauver courtroom at the federal courthouse, the old federal courthouse in Las Vegas. It was our original federal court in the state of Nevada. When Kefauver and his group came to Las Vegas, they used one of the courtrooms in that federal courthouse to conduct the hearings. Millions of Americans nationwide followed the televised and radio broadcasts, bringing the reality of national crime to the public light. They didn't have YouTube back then. The core requirements is that they have to find an enterprise, bunch of people working together, and a pattern of racketeering activity involving at least 2 predicate crimes within a 10-year span. So in other words, if they could find, hey, all these people worked together and there was a bribery that came out of this, and all these people worked together and there was some skimming out of a casino that came out of this, that opens the door for RICO charges so they can go after the people at the top. Prosecutors went on a rampage with RICO in the 1980s, famously using it as, quote, an atomic bomb to dismantle major mafia families by linking the bosses to the operations run by the subordinates. The Lucchese crime family was one of the 5 families that dominated organized crime activities in New York. The prosecutors used RICO to bring that family down. As the law evolved a little bit, they started using it not just against what we characterize as, this Italian or Sicilian mafia type organizations, but also like gangs, drug cartels, corrupt politicians, and big time organized white-collar crimes. RICO is used to bring down the Latin Kings. In 2016, 16 members of the East Coast Crips out of Los Angeles were brought down with RICO. Same year, West Coast Crips, 34 out of 36 defendants pleaded guilty or were convicted by a federal jury in a racketeering conspiracy involving multiple murders and robberies. And it was done so with RICO. Suave. The Tongan Crip gang out of Salt Lake City. In 2011, 6 members were convicted of violent crimes and RICO-related conspiracy charges following a multi-agency federal operation. Utah, where this case is, adopted its version of the federal RICO statute in 1981. Rather than naming it the RICO Act, Utah calls it the Pattern of Unlawful Activity Act. Barring, while the federal act requires 2 instances within the 10-year time frame I discussed earlier, the Utah Act is slightly different. It requires 3. That case started out in state court. There were concerns expressed by Reckless Ben that, hey, I'm kind of being home courted here. You know, I mean, this is your home turf and it's not my home turf. And I'm from LA and all you guys are from Utah. This is some big conspiracy against me. He didn't feel like he was being treated fairly in state court, or thought he wouldn't get a fair shake in state court. And so his attorneys removed the case to federal court. How do you remove a case to federal court? In this case, the reason why it was removed to federal court is called diversity jurisdiction.
What in the hell's diversity?
In diversity jurisdiction, you have to have complete diversity. That's one of the elements. And what complete diversity means is, you know, in court cases, you have Smith v. Jones. In this case, you have Bricks and Minifigs et al., which is some Latin that means, and everyone else on that side of the V. And then you have Reckless Ben et al., which means everyone else on that side of the V. And you know, you got that V in between the plaintiffs and the defendants. There's a V. So what complete diversity means is that no one from this side can be from the same state where the controversy exists on this side. You have to have complete diversity, meaning if any one of the defendants was from Utah or was domiciled in Utah or was a Utah resident, then they wouldn't be able to remove it to federal court. We already know Bricks and Minifigs is headquartered out of Provo, so that's where their corporate residency lies. One of the named plaintiffs is an individual who lives in Utah, but no one on the defendant's side lives in Utah, so they check the first box and having complete diversity to remove to federal court. The next question under diversity jurisdiction is the amount in controversy. The federal courts say, we're not going to hear every single little controversy just because you're from two different states. It has to have some serious consequence for us to even listen to it. And what the federal court has decided is it has to be an amount in controversy in excess of $75,000. And in this case, it is an amount in excess of $75,000 because Bricks and Minifigs is seeking over $1.3 million. And so that's how it was removed to federal court. And that's where it's staying because the federal judge permanently confirmed that the move under diversity of citizenship was a lawful act by the defendant, and it's staying with the federal court now. Whether Ben thought he was being home courted or whatever in state court, he wound up going to federal court. And interestingly, the judge presiding over his case now is a graduate of Brigham Young. The other two types of federal jurisdiction are whether there's a federal question. In other words, if a federal statute has been violated, you can get to federal court that way too, by removal. It can start in state court. You can remove it if the case substantially asks a federal question. Other cases that go to federal court is where the United States itself is one of the parties, either as the defendant or as the plaintiff. The judge in the federal court case probably grew up with Legos, lots of Legos. He was born in 1971. But Ben did see some relief when he got to federal court. As you might recall, he was under all these restrictions, a temporary restraining order or something to that effect, where he couldn't talk, he couldn't post videos, all this stuff. We go over that in another episode. But it's when he got to federal court that the federal court looked at that and said, no, I'm going to lift some of these restrictions. They're too much. What the federal court stated is that Ben cannot be prohibited from discussing the plaintiffs, commenting on the lawsuit, publishing court filings, or engaging in investigative journalism and commentary across social media platforms like YouTube and TikTok. This modification from the federal court allowed him to immediately release part 3 of his Lego documentary series on July 8th, 2026. So what remains restricted? The court replaced the broad state court gag order with a narrower preliminary injunction. And under the narrower order, the defendants are still blocked from making threats, stalking, or trespassing. In other words, hey, don't break the law. They're still prohibited from coming within 100 yards of Bricks and Minifigs offices, stores, or owners. They're prohibited from doxing or publishing personal contact information of any of the people they don't like on the BAM side. They're prohibited from staging confrontations, property destruction, or impersonating people to get signatures or recordings about BAM. They're also prohibited from soliciting, in other words, asking for, going out there and say, hey, psst, psst, leaks or confidential business information from employees of BAM. So who's being sued with Reckless Ben? Brian Mansell, Victor Wenyan, and Does 1 through 5. Let's talk briefly about who these people are. So Brian Mansell is the person selling logos for his elderly father. He's in the lawsuit. Victor Nguyen, he's a content creator. He's a videographer, a key production collaborator for the Reckless Ben YouTube channel. Kind of like Kevin, our guy behind the camera. And then also sued with these three folks is, of course, the Reckless Ben entity and Does 1 through 15. What are Does 1 through 15? Well, Does under the law means we don't know the identity. You've probably heard, I don't know, John Doe or Jane Doe. Those are Does. They're both in the Doe family, meaning we don't know who they are. And so when they allege Does 1 through 15, what they're saying actually, from a legal standpoint, is that there might be 1 to 15 other people involved that we don't know their identities yet, that we might add to the lawsuit. Now, why wouldn't they just amend if they learned later? Well, it's a little easier to replace one defendant with another defendant, long explanation by it, than it is to add a new defendant. So the Does 1 through 15 are placeholders, and if they find the true identity of someone else involved in these RICO charges, then they can just simply replace Doe number 1 with whoever, Doe number 2 with whomever, so on and so forth. So if we really break this down, what they're saying under the RICO charges, because they have multiple defendants, is they're saying Ben conspired with other people, 2 of which we know he conspired with, or we think we know he conspired with, and then up to 15 others that we don't know their identities that he may have conspired with to commit crimes against us, and that's why we think he should be charged under RICO like a mafia boss. So where are we at in the case right now? We're in limbo. That's exactly where we are, because we're waiting. There's nothing else scheduled in this case anyway. We're waiting for a mediation, which could be a good thing or a bad thing, but let me first explain what a private mediation is. A private mediation is a voluntary and confidential process where 2 sides hire an independent third-party neutral, somebody that doesn't care about the outcome on either side, to help them resolve a dispute outside of court. It's a form of what we call alternate dispute resolution. The key features of it are self-selection of the neutral negotiations expert, that's what a mediator is, flexible scheduling, a focus on mutual agreement rather than a judge's ruling. A judge can only give a ruling that's either this side wins this side loses this side wins this side loses this. It's pretty black and white. But at a mediation, a lot of other things can happen that a court simply can't do for disputing parties. Possible benefits of a mediation is it keeps personal or business details out of the public record, out of the public domain. Control. It allows both sides to at least have some control over the resolution of the case. It allows control over custom fixes that might fit their specific needs. And then cost and speed. We already know that it's been very expensive for Reckless Ben. In one of the other videos that we went over, he talks about how they've run out of money in production to do animation, so they started using Lego figures to do their quasi-animation. Here's what we don't like about mediation as it pertains to this case, though. A court decision or a judgment is part of the public domain. Anyone can review it in detail. Our courts are public institutions. They're paid for by tax money. We get to know what they're doing. But in a successful mediation, almost all of them lead to a confidential settlement agreement. So for us out here, if they do resolve their dispute at a mediation, we may not know what really happened. Maybe this is the end of the case in terms of what the public can know about it, because when it's resolved, it might be resolved where neither side can talk about it.
I want to know.
An adage a lot of times given for what mediations can do that courts cannot do is the soybean story. Soybean! I don't know if it's true or not, but I've heard it from so many sources. It has kind of permeated throughout the legal community that there are two different companies and they've ordered large shipments of soybeans and they go to the shipping yards and both companies have a bill of lading saying all of these containers with all of these soybeans are mine, and there's two conflicting bills of lading. And so at the shipping yard they say, we're not getting involved in this dispute. We're not giving the soybeans to anybody without a court order. So you better go to court if you want these soybeans. So they both sides race off to court. They're filing emergency motions to get in front of a judge immediately because these are perishable goods, soybeans. They can rot. There won't be any soybeans to fight over unless they can get a quick resolution. Court cases take years. They need a quick resolution before these things rot. So the judge says, you guys better go to mediation before these things rot and figure out something quick. They get to a mediator as quickly as they can. After they get to the mediator, they're mediating back and forth all day. The mediator's going back and forth, can't really resolve the case. And finally, the mediator asks in one room, what do you do with the soybeans? And in that room, they said, well, we make soybean oil. And he said, how do you make soybean oil? And they said, well, we take the shells off and we boil the shells and the oil floats to the top and we skim the oil off top. But we've got it in a, kind of in a factory type process, but that's essentially how it's done. And then he goes to the other room and says, what do you guys do with the soybeans? And they say, well, we make tofu or something like that. And he's like, well, how do you make that? And they said, well, we take the beans out and we do this with the beans and that. And he's like, what do you do with the shells? And like, we throw them away. And so at a mediation, something a court couldn't do, these two parties started doing business together forevermore because now they could go in as partners on all of their purchases for soybeans, and one side would take the shells and the other side would take the soybeans. So the possibilities are endless with the mediation. What could even happen at mediation in Ben's case is maybe they could say, hey, we yield, you're a great YouTuber, we'll pay you a bunch of money, let's just end this thing, and we'll also give you a percentage of our profits over a certain amount if you help promote our company and restore our Lego company back into a more profitable venture, and we'll pay you over 10 years. I mean, all kinds of things could happen. At this point, I'm speculating, but I'm just trying to give you an example that anything can happen in mediation, but what almost always happens at a mediation is that we'll never know what happened because it'll be under a confidential settlement agreement. So Reckless Ben has been in the media and social media at least, and made demands and say, hey, I'll settle if you do this. And that's an offer where if they accept it on the other side, it'd be the end of the case.
They can say they're sorry by doing the chicken dance.
But that's not really mediation. That's more negotiation and doing it through the public domain. Is Ben really a gangster, kind of like the Mafia taken down by the RICO Act, kind of like the Bloods or Crips being taken down by the RICO Act, or the Latin Kings? I think that's a little crazy, but leave your comments below. Let us know whether or not you think Reckless Ben should be charged like he's a mobster. Hey, check out this video right here. You can see me react to, and it's an initial reaction to Reckless Ben in court before he was represented by attorneys. And if you know nothing about the Reckless Ben case, I try to break it down in about 3 minutes in this video right here. Did I say logos earlier? Logos for his... Yes, I did. I meant Legos.